I want to tell you that I was reading an article by Joe Coughlin, who is the executive director of MIT Age Lab. And his article, you may have seen it, was in LinkedIn. And it was talking about, thinking about, well, how do we get back to normal? And basically the message was, there's going to be a new normal. And I'm sure all of you have heard this over and over. I have. And I thought it was interesting because one of the things he said is that change is coming, but it was coming long before COVID. It's just that COVID was an accelerant. So for instance, there's been social and economic changes on the horizon in 4 major areas that he speaks about. Education, right? Because now education has gone more online and out of the classroom. But anyone who's taken Coursera, listened to TED Talks, this was coming long before COVID. It just has been accelerated. And one of the positive things is, for instance, in China, is the democratization of education because education has been online. The other area is working from home. And I'm sure all of you have seen the acceleration. Not that there wasn't working from home. We've had working from home since the 1970s. But I know just in our own office, there were 38 people working from home for the last three months, which I never dreamed could happen. And we're making changes and innovations, and it's leading to positive social change for our families and our work-life balance. Home shopping, I used Amazon before. I'm now living with 5 millennials. You could bet I've gotten to know the Amazon and FedEx man very well. Both are men. I feel guilty. I try and tip them a lot. But that is the new normal, as is health in the area of health and telemedicine. But that's not the only places where there is change. And today, I want to talk to you about change in the area of estate planning. My own personal beliefs, and I've been practicing for 30 years, have changed as a result of what's happened at COVID. But those changes were in the works long before COVID happened. One of the things when I started my practice 25 years ago, I used to say, I want to do the seminar about why you don't need a revocable trust, as kind of against the claims that everybody should have a revocable trust, which sometimes I even thought were abusive. And many times over the years, I would give my lecture and I would tell people, listen, especially in a place like Suffolk County, there is really no delay in getting letters testamentary, probating a will, and that maybe the trust is not the best area. Now, before I get into that and why and comparing revocable trust and probate, let me, for those people who don't understand, explain. When you have a will, that will, in order for it to be valid and for you to be able to act as executor, must go through the court process. And you have to give notice to people who would have inherited had you died without a will. That is what we call probate, as opposed to a trust, which is a living document in which you create during your lifetime. Typically, when you create this trust, and now I'm talking solely about revocable living trust, you are often the trust maker, the trustee, and the beneficiary during your lifetime. And then when you die, a successor trustee takes over and manages your assets and distributes them similar to what the executor would do in a probate process. So often my lecture would be that in order to substantiate the need for a trust and the cost of doing a trust, which is more expensive because you have to create the trust document, and the idea is to fund the trust, which is means that you have to retitle assets in the name of the trust. Prior to 1997 and 1998, an asset could be deemed in a trust if it was on Schedule A of the trust document. After the law was changed, that was no longer necessary. And in fact, it has no legal impact. So whether your Schedule A is filled out or not, The only way to know what's in the trust is to look at the asset and how it's titled, be it a bank account, a stock account, a car, a house. You have to actually change the name to the trust, and we call that funding the trust. So if you were going to balance the cost of a will versus the cost of doing a revocable trust, which, by the way, you still need a will just in case there are assets that are not in the trust and be funded. When you balance that, you have to see, well, is there some reason why the probate process would be expensive? And often it would be, well, if you're disinheriting one of your heirs. Because remember, what I said is to probate a will, you must give notice and the right to object to anyone who would have anyone who would have inherited from your estate had you died without a will. So for instance, if you have 3 children and you're disinheriting one, if it's a will, then notice has to go to all 3. Hey, mom died, she's leaving this amount of money and you're getting none of it. Come to court, you have the right to object. And that's why Surrogates Court, especially in Suffolk County on Tuesdays, is very crowded. We tend to be litigious, and that's just asking for it. So in a situation like that, I might definitely say to someone, you should do a revocable trust. The other thing is if you own property in different states, because the idea is everywhere you have dirt, everywhere you own dirt, real property, there must be a probate, because each state has sovereignty over its own property. So if you own property in Vermont, New York, and Florida, then the title to the property should be transferred to the trust to avoid probate in those 3 states. Another area where it comes up is if you have unknown heirs. And I like to give the example of my client who died, not much money, lived in New York City. He had about $250,000. I had dealt with his power of attorney, who was also his beneficiary. But when he died and they went to probate his will, they had to find all of his heirs. And his father was born in Egypt. His mother was born in France. He had no siblings. He had no wife. He had no children, which meant we had to hire genealogists in those countries to determine who his next of kin was, to give notice before we could probate a will that had roughly $200,000 in it. It was in New York City. It was a long, drawn-out process that could have been handled had we had the assets in the trust. Then those agents who were agents under the power of attorney could have been trustees, and they would have been able to pay his bills and pay the money out to themselves as beneficiaries. So if there are unknown heirs, that is definitely a case when you would want to do a revocable trust. Another area is if you have a disabled beneficiary. Because of the delay in probate, if you have a disabled beneficiary, the court will have to stop the probate process, appoint a guardian ad litem for the disabled beneficiary or disabled heir who's not being inherited, who is not inheriting, and that is time and money. And so I will tell you, I even had some cases in other jurisdictions where over time my idea changed, because I realized, well, Suffolk County, by and large, is not a problem in terms of probate, but it could be so in other counties where there's a backlog in the courts. And in one jurisdiction, we waited about 1.5 years to get a change of trustee on an existing trust that was in a will, where we had to go through the court process. And that was pre-COVID. So based upon the assumptions that the court would always be around and not close down, as it just has for 3 months, that was the exception. So I thought, well, maybe in some counties where I know the process is slow, we should be telling people that a revocable living trust is the way to go, and that a will was still a good idea in some of the other counties, and doing that same analysis. And the problem is that those assumptions are no longer valid. And what has happened is, through what's happened with COVID and the court closing down for roughly 3 months, all those assumptions go out the window. Does anyone have any questions before I go on to what happened during COVID?
I don't have any questions. However, I do have someone with their hand raised. So if you, instead of raising your hand, if you could go to the bottom of your screen, there is a Q&A section. You can type in your question and we'd be happy to answer that for you.
Okay, so I'll go forward. So let's break it down. So take a situation where the court closed down in March and someone dies in that period when the court was closed down. There was no probate. We could not get a will to probate. And if there were things that had to be done, we couldn't do anything about it. So for instance, if we had to sell a house, that could be a problem. Maybe we had someone who had died a few months before the courts closed down, and they had a real estate deal, and they were ready to close. The buyer was ready, willing, and able, had a mortgage commitment that was about to run out, and it was based upon the assumption that the executor who didn't otherwise have the power. Sometimes there's a power in the will for an executor to sell the house, but sometimes you have to make a motion. If there is no power, maybe perhaps the estate's insolvent and the real property has to be sold to pay expenses. That is done by motion. And we did have a similar case to that we were getting ready to do the motion, knowing there was a neighbor that was going to buy the house, and we could not get that motion through the courts. That was a problem. It was a problem, one, for the estate that was carrying the charges on the house. And it was a problem for the beneficiaries who saw money going out the window. And it was a problem for the buyer because their mortgage commitment was running out. And nobody ever thought that would happen before, right? Now, if that property had been in a revocable trust, a properly written revocable trust, that would not have been a problem. Why? Because one, when the person created their revocable trust during their lifetime, and it was done right, they had all the powers that they needed. Now, let me stop there before I talk about powers they need. I've seen lots of trusts, and they don't have any powers in there. And one, I've seen that's marketed all over the country. I'm appalled at this. It's about 4 pages long. It purports to be a revocable trust, and meanwhile it has no powers in there. It's not worth the paper it's written on. So there may be some assumptions in under the estate powers and trust law of powers that the trustees have, but a properly drawn revocable trust will be all-inclusive and give the trustee powers to do things like mortgage, like borrow money, like sell real property, and I can go on and on with the list. If it's not done right, then you have a problem because you may end up having to go to court otherwise. So if it's properly drawn, and this was funded during the person's lifetime, and then they died, and we have a pandemic or close down of the courts for whatever reason, the trustee can still continue to do business and do what the trust business, far superior. And it started to make me think, well, maybe there's something more to having a revocable trust than what I originally assumed before. Before I was thinking about all the different people in terms of probating the will. I was not thinking about if the court was not available. In terms of signing a trust, what if you create a trust during COVID? One of the things that we were lucky, and this is the first time I've ever seen it, was the governor passed legislation or an executive order so that we could do remote signings. And that has made a difference. We don't know that that will always happen. So in terms of getting your affairs in order, that should be done and be done on an ongoing basis so that when you change assets, you be sure to put them in the trust, because if they're not in the trust, then the trustee can't act. Also, in terms of what has happened over time, I have noticed that clients, I have a client now who says, why do I need all these powers? It's too complicated, I don't understand it. And I think that sometimes it scares people and they think, well, trusts are just for wealthy people. But as I showed you in the example of my client who had parents in in another country. His estate wasn't that large. It was only a couple $100,000. And meanwhile, the estate was charged a lot of money for genealogists in doing that. So it's not just for wealthy people. And I think one of the things that has changed for me in terms of COVID is it now has become more of a foundational estate planning tool and not just in those special situations. The other note I want to make is even if you choose to use a will, it's very important that the will has all-encompassing powers. For instance, if you did want to sell real property, it doesn't hurt for you to speak, if you're an attorney and you're drafting the will, to ask your client, if you want the property to be sold at your death, put a clause in the will that says that the executor has the power to sell the property and distribute the proceeds to the residuary. Because if they don't and the estate is not insolvent, they're not going to be able to sell real property. And if the estate is insolvent, they will be able to, but only after making a motion in court. Are there any other questions?
Yes. Can a will have two executors acting jointly, my lawyer and my relative?
Oh, okay. That question I can answer. Okay. Yes, you can have co-executors. Oftentimes, it could be a lawyer. It can be two family members. If a lawyer is acting as an executor and the lawyer drew up the will, they should have an affidavit that the client realizes that they would receive fees as the attorney, if they act as the attorney, and also commissions as an executor. They can act together, and there are many different reasons why family members, sometimes I have clients who say, listen, I want a third party in there to make sure that everything is carried out, and I don't want my son or daughter who's acting as co-trustee or co-executor to have any problems. But that's something, again, that I would speak to the client during the conference, the pre-conference, before you draft up the documents. And that comes to another point, is that I really think those are things that you need to speak to an attorney about. And now I'm going to make my claim about internet wills, because along with when you talk about the good things that have come out of COVID, there's things that I think are negative. And so there's more of a reliance or talk about using documents from some internet companies without using an attorney to do it. And what I say right now is that when we are drafting documents, the documents are important for the reasons I said, but even more important is the advice that you get from an attorney. And that's why we're counselors at law, and we give counsel to others. And I think that sometimes when you rely upon, and not sometimes, all the time, when clients think, well, I can go on the internet and just draft up a will, they miss many of the points. And I have yet to see one that comes out of one of the internet providers that is complete and hasn't caused some problem and hasn't left something out. So I'm not impressed with the level of it. And I think getting legal advice is more important. And sometimes just certainly it's important, and just as important as the document that's drafted. And the other thing is that when lawyers do this, and we do it all the time, we see the problems that may come up over time. The other thing is funding the trust. As I said before, if you don't fund the trust, you may have some problem in, there were even some problems. I went to the bank during COVID. I was doing a financial transaction, buy a house, and I waited online in my car for 2 hours to get up to the teller. I had to go to a bank 40 miles away to open up an account, and it was limited hours. Never before has this happened in my life, or probably yours. I didn't expect it. And then the light bulb went off. I said, of course, this is a very good reason to do a trust. The other reason that you might do a trust is you are beyond a person dies, the grantor dies, the testator dies, and how do you probate it? is there may very well be, and hopefully there are, ongoing trusts for beneficiaries or heirs. And typically, two come to mind. One is a descendants or inheritance trust, and the other is a special needs trust. So I would say that 99% of the time, my clients leave assets to their heirs, usually their children, but it doesn't have to be. It could be an aunt leaving it to siblings or children. They want to protect them. And the way to protect it is to not leave it to them outright, but to leave it to them in further trust. And so there we go with the question of, well, why don't I just name people on my bank account and then I can avoid probate that way? And again, it depends. This is why you need legal advice. It would depend on how much are you leaving. If it's $10,000 and you're leaving it to two people, right? Say you have a niece and a nephew and you leave it to both of them, you might say that's not enough of a reason to worry about putting in a trust. And I would agree with you. And if I said, well, and what one does, and you say it's okay if it goes to the other one, well, that trust account, and that's what we call a bank account that has beneficiaries named on it, works just fine for you. But if you're leaving any significant amount of money to an heir, why not protect it? And in New York State, you can leave it in a trust. They could be their own trustee. It will be protected from divorce, from general creditors. It could be protected for Medicaid purposes. That would be the supplemental needs trust, or for any government benefits. And oftentimes people come in and say, I want to protect my assets. Well, there's a limit to what we can do when it's your own money funding your own trust, as we know from Medicaid trusts, where you can protect them from Medicaid, but not from general creditors. In a descendants trust where someone else leaves the money to an heir, they can have protection from everyone. Divorcing spouses is always a big one. 50% of the marriages end in divorce. Those are the statistics. And also in the pandemic, sometimes people come to me and say, listen, my kids have money, they have no problems, they don't need that kind of protection. And boom, something like this happens, and maybe they didn't pay the mortgage payments or the car payments or student loans. So why not leave it for them in a trust, a descendants trust, an inheritance trust, a supplemental needs trust if they get sick, and to protect government benefits? They always, if it's a descendants trust, there's always a way to get money out of the trust to be used for them, or to buy things inside the trust for their benefit and enjoyment. And if you create it in a living trust document, it's created upon death when it's funded, and it's an ongoing trust. And again, having powers in that trust so the person can operate whether or not there's a court around. And so on the first, when I used to talk about this, it was the cost and expense of going to the court. We've added a new component. It's more than the cost and the expense. It's the inconvenience and the fact that we don't know what the future may bring. And those ongoing trusts, you also don't want to be tethered to the court for all those reasons. So now what happened also during this pandemic is I would have people come to me and say, well, it's too late to do a trust now. I just need some documents. I haven't done anything yet. I'd like to create a will and I'll do a trust later, which is fine. There's many options that all of the things we talk about, descendants trust, supplemental needs trust, can be drafted into a last will and testament. Typically, I will tell you that if we are going to fund the descendants trust for their, say, their children, or a disabled beneficiary in a supplemental needs trust, and we know the person is disabled, we might create a separate trust and the will just pours into that trust at the death of the parent. I'm using an example of a parent now, but it doesn't have to be. So say that I have a couple and they come in and they have a house and they have some life insurance, they have some other assets, maybe bank accounts, and they're going to divide them between their two children, 50-50, and one child's disabled. we might very well do a separate, and I would recommend a separate descendants trust for that child who's disabled, so that when the parents die, it could be poured into that trust. In addition, if other family members, like a parent, an aunt, an uncle, want to leave that disabled child money, they can also name the same trust as the beneficiary. So I think that having those, even if someone during a time of COVID is creating the documents, you can still do those documents even though you may not be able to fund the trust, and they may not be funded till death. And it avoids the problem of doing it over again. And so to me, I have changed my mind in terms of trust. I see it as a much more valuable tool than I ever did. I still think you have to go through the analysis of whether it makes sense or it doesn't make sense in your particular case, but it has changed my idea. And I will tell you, especially if there's any financial advisors who are here, the same thing happened in 2008 when we had the stock market crash. Prior to that, if you had spoken to me, I wasn't a big fan of annuities for a number of different reasons, and I was vocal about it. And I stood corrected after 2008 because a lot of my clients, especially my older clients, did not get hurt with annuities that had a fixed rate, or it really turned my head. And there's a place for that as well. And I think each time something happens like this, we have to be adaptable. We have to change our advice. We have to see what is the new normal, and then change our advice towards what we tell clients to do. And revocable trust for me has been the big change in terms of estate planning. Thank you.
Okay, first question. Can I make a 14-year-old nephew one of my beneficiaries?
If you're talking about making them a beneficiary under a trust, absolutely. The idea is if you have either a will or a revocable trust and you name them as a beneficiary, you would create an inheritance trust in that document. After you die, the trustee would make the distribution to that trust, and presumably your document will name a trustee for them. And usually the way I like it is you name a trustee for them if they are under 25 or 30, and then at a certain age they can become co-trustee. Typically my documents say 25, and at age 30, for instance, they can name themselves as sole trustee. But you do not want to name a 14-year-old on a bank account, a life insurance, or retirement plans. And I see it all the time because it's the worst thing you can do. If it's a retirement fund, the court's going to make you have a guardian appointed if it's paid outright to them. Guardian appointed, and the money will most likely have to be cashed in. There are some ways in which you can keep it, but it's very complicated and expensive. And it's going to sit in a bank account until they're 18, and then it will be given to them at 18. And I don't know about you, but I don't know most 18-year-olds, by the way, they're applying for college then to get a lump sum. And financially, it's a disaster. And if it's a retirement account, then the taxes are going to have to be paid. So I much prefer to name a trust. It's the better way to go. That holds it for the child, to protect it from creditors, from themselves, from others, and to reduce the tax liability. Same thing with life insurance. Not uncommon, young couples come in, they say to me, well, I have life insurance, who's the beneficiary? My wife. Who's the contingent beneficiary? My children. How old are they? 4 and 6. It's a nightmare. You must create a trust to be a receptacle for those benefits, wherever they come from. Thank you.
Next question. Can CDs be put in an irrevocable trust?
Can CDs be put into an irrevocable trust is the question, Liz?
Yes.
Yes. So when you say put CDs in an irrevocable trust, what it means is that the trustee would open up a CD at the bank and give the bank the irrevocable trust document, or a certification of trust if they accept that. The title would be in the name of the trust, and it would use the trust tax ID number. All right, thank you, everyone. Take care.